welcome to this national conference. I want to start first of all, we start the first part of the session. We'll ask Ms. Moody, and I must say, although it's not the appropriate time to say thanks comes at the end, that without Mr. Moody and without the Jindal Global Law School support, this program would never have taken place. We got total support. And we are happy to bring so many of you only because of the extraordinary participation of the university. Thank you very much, Mr. Moody.
Good morning. On behalf of the Center for Human Rights Studies of Jindal Global University, I want to extend a warm welcome to all the lawyers, participants, activists, speakers to this national course on prisoners' rights. I want to extend a warm welcome to Mr. Chaman Lal, former Director General of Police and former Special Rapporteur to the National Human Rights Commission, and Mr. Colin Gonzalez. In fact, we are so delighted these two extraordinary individuals are with us today. And I have closely worked with Mr. Chaman Lal in the National Human Rights Commission. And I have seen I have been a part of many fact-finding missions along with him. And the kind of passion, sincerity, dedication is absolutely outstanding. And in fact, he worked on a honorary basis with a salary of 1 rupee. And but what he did there, be it in starvation deaths in Odisha, be it in many other matters, is truly remarkable. As a special rapporteur, there is hardly any prison that he has not visited in the country. And there are prisons where he has visited multiple times. In fact, I remember one experience. We went to Ranchi, and there was a hall 1/4 of the size, and which was housing some 600 people. And Mr. Chaman Lal asked them to lie down. None of them could sleep with their legs stretched. Then you can imagine the kind of overcrowding that was there. And so the prisoners were taking turns in sleeping. And when in a small room, when you put some 600 people, you can at once imagine what would happen to them in case there were any communicable diseases, any infectious diseases. And so he painstakingly documented all the problems from the human rights perspective, be it sanitation, be it rehabilitation, be it toilet prisoner ratio, and ensure that there had been a change, and he also monitored the follow-up of implementation. And today there is a wealth of reports that he has submitted either on border labor situation or on prisons or on mental hospitals. And in fact, in the height of terrorism in Punjab, he exposed the way to address the terrorism issue from a rights-based approach. And he has been conferred with Padma Shri, and also been the only activist who has been recognized with the Nani Palkiwala Award for Civil Liberties and Justice Krishnayya's Award for Social Justice. And it's not possible to really exhaust the multiple talks that he has done. And so we really welcome you, sir, and we are really honored that you come to our campus and you be a part of this program. And Mr. Colin has established this human rights law network and fought many important cases, including the right to food case. And what he has done is remarkable. And we are really grateful, Colin, that you have chosen to partner with us, and we really welcome you for this. The university was established in the year 2009. We started with a law school with 10 faculty members, 100 students, and subsequently we established separate schools for business, international affairs, public policy, liberal arts, journalism, and this year the School of Art and Architecture and School of Banking and Finance are commencing courses. We have about some 3,600 students and about 300 faculty members, and we have been maintaining 1:12 faculty-student ratio, and we are deeply committed to research. The vision of the university is to be a center of excellence to promote teaching, research, capacity building, and community engagement. And there are over 55 research centers in all the schools that are undertaking cutting-edge research. We are one of the youngest universities which have been got into the international rankings by QS. There was a ranking of the universities in the BRICS region of 9,000 universities. We have been placed in the top 300 and the youngest university in India to get into the international QS rankings. And recently, the QS also gave us a diamond rating, overall diamond rating. And we have also been recognized as the cleanest campus under the Swachhata rankings of the higher universities. And we are one of the few private universities in India which have been conferred autonomy by the Ministry of Human Resource Development a few months back. The Center for Human Rights Studies, of which I am the Executive Director, has been working in many issues related to human rights, including abolition of death penalty, extrajudicial executions in Manipur. Our students have interned with the Human Rights Network and spent several months in Manipur, documented the cases of extrajudicial executions, and also helped the amicus curiae and the process of securing justice for the extrajudicial victims. And we have also we have a human rights clinic under the center, and we also organize a series of important lectures and conferences. Coming back to the topic of this conference, in fact, Winston Churchill is not a great hero, but he said something remarkable. He said, you can understand the standard of a civilization from the way it treats its prisoners. It's quite significant. The entire quote is long, and I don't want to go into details, but it's very important to know that how we treat these helpless people who are behind the high walls of prisons without any access to the civil society, without any scrutiny by the outside world, and also subjected to a number of inhumanities. So their rights are extremely important, and if you see the International Covenant on Civil and Political Rights, there is a clear recognition that all persons who have been deprived of their liberty shall be treated with humanely, with respect to their inherent dignity. And there are many challenges in prisons, and in the DK Boswell judgment, there's a very clear pronouncement that custodial violence is a calculated assault on human dignity, and whenever human dignity is wounded, the flag of humanity shall fly upmost. Very profound words. In spite of our constitutional values, in spite of the international treaty which we have signed, yet the custodial violence continues in many of our prisons. If you take up mental health issues, about 6 to 7% of the country's population has some mental health issue or other. And if you look at the prisons, the proportion is 3 times or 5 times more. And yet, it is not seen as a mental health issue and not treated as such. The moment you don't acknowledge something as not a mental health issue and treat it with a different approach, then you can easily imagine what its consequences will be. And 1/3 of the prisoners suffer from serious mental health issues. And if you add the substance abuse, it goes up to 65%. So, and there are of course issues relating to death row prisoners. There are issues relating to discrimination. There are issues relating to the access to their relatives, corruption, and many other issues. And we are so delighted that this national course on prisoners' rights has been organized, and then we are going to discuss legal aid and many other issues. And once again, I wish to extend a warm welcome to all the lawyers and activists who have come from various parts of the country. I hope you will have some fruitful deliberations in the coming days, and thank you.
Thank you, Mr. Murthy. And I also extend my warmest greetings to Mr. Chamanlal, who's been an old friend and comrade of ours in this struggle for justice on prisoners' rights. You have a galaxy of the country's leading experts on prisoners' rights coming here and spending time and interacting with you. You will notice on the program that we have an evening session today and tomorrow where the lawyers speak. The lawyers who have come from about 15 states of India will be speaking. So all of you who want to speak, I want you to give it some thought from now onwards and think of what it is you want. Torture in prisons, custodial deaths, terrible conditions in prison, lack of legal aid, health conditions in prison. So the whole range, I want you all to just give some thought, because time will be very short, so we probably give you 5 to 10 minutes, a very little bit of time. But we want every one of you to come up on the stage, and we want to record that from your area and from the place where you work, these are the conditions of prison. One of the important focuses is how does one get into prisons and provide legal aid to prisons. So prison access, prison visits, getting information from prisoners, and doing their cases for bail, for trial, whatever. The other big focus, and now I want you to think very carefully about this, because at the end of each day we will probably get ideas from you as to what it is you want to do. We do want to use this meeting to promote a spate of public interest litigations in all the high courts. The number of litigations being done, the number of PILs being done is very low. And we know how terrible the conditions are. We know what kind of things happen inside the prisons. We know overcrowding. We know all these facts. And yet the number of PILs done are very low. The Supreme Court has taken off now with Justice Lokul playing an active role in the Supreme Court. But we do want the focus to be on the high courts of the states. So we want all of you to come up with ideas. There's also a session on how to do a PIL, and we will guide you when you do your PILs, but take that as one of the positive outcomes, results of this program, that we will do as many PILs as possible in the high court. And now, I invite Mr. Chamanlal. Thank you, sir. Thank you, sir.
Mr. Kansami, Mr. Murthy, ladies and gentlemen, I consider it an honor to be invited to deliver the keynote address at this prestigious institution. I thank Mr. Akmal and Mr. Murthy. It is also a privilege for me to be participating in an endeavor of Mr. Gonzalez, who is a dedicated, selfless crusader for social causes and excellent defender of human rights, who has contributed immensely to the enrichment of human rights jurisprudence in this country. I congratulate both Mr. Gonzalez and Murthy for having taken up the training program of lawyers, and I'm glad to see that there are young lawyers. Because prisoners are one of the most vulnerable sections of society when it comes to human rights protection. We say all human rights for all, and they need equal protection, but there are some vulnerable sections which need special protection, extra protection. Women, children, bonded labor, mentally ill persons, and in that very list we have prisoners whose rights demand special consideration and greater protection from all institutions. You will agree with me that the prisons all over the world, and particularly prisons in India, are unclean, unhygienic, ill-equipped, ill-manned, by staff that is overburdened, ill-paid, ill-equipped. These are depressing places. And they damage both those who are kept there and their keepers. The dehumanizing impact of all that. And there is no possibility of any improvement in the sense that despite all the reforms, all the administrative actions that have been taken, things haven't improved. Why? Because in India, although our prison population is not alarmingly high as in US, it is just 30 per 100,000, and in US it is 700 per 100,000. But here, the peculiarity is that more than 75% constitute, they are under trial prisoners, those who are still not been held. And prisoner conditions are bad because prison, as certain studies show, in India are housed by more than 80% who are poor and powerless. Nobody considers them worthy of expenditure. Spend time, money, energy on improving their conditions. And that's why the prisons remain as they are. Now, till independence, the society was also totally indifferent to the rights of the prisoners. And they thought that these are the people who are suffering God's punishment. They are there for just punishment. And the judiciary also had hands-off approach. But over the years after independence, we found that there has been a progressive, there has been a trend. And I want you to understand that trend. The trend through pronouncements of the Supreme Court, trend was, the earliest was total deprivation of liberty. Then it became retention of residual liberties. Then recognition of prisoners' right to humane treatment consistent with his dignity, human dignity. And last, the recognition and acceptance by the state that it has an obligation to rehabilitate and reform them, because criminal activity is a joint failure of society and the individual. Crime arises from individual factors and environment. So the society must assume its responsibility in reforming the prisoner so that he gets back and gets integrated in society. And this has happened, as I said, as a result of the Supreme Court. The Supreme Court, a series of principles they laid down, Socio-Legal judgment. The first thing they said was, prisoners are not the slave of the state. They are not the slaves of the state. A person does not become a non-person on entering a jail. A prisoner is entitled to all rights except those affected by the punishment is incarceration. So no deprivation that is not explained by the fact of incarceration is authorized and justified. And the next, that a person goes to prison as punishment and not for punishment. The fact that he is a prisoner is a punishment. It should not be aggravated by making things difficult for him in the future. These principles and a series of pronouncements of them, and I'm sure the course has been very brilliantly structured, but I want to emphasize at this way that all these judgments, starting from Osama Khatun in 1978 about the language under trial prisoners, Sunil Batra 1978 about solitary confinement and use of facts, Charles Sokra's case, where the Supreme Court said the right to life and liberty. Life is not mere survival of human existence. Life means life with dignity and protection against torture. Then Colin Mullen, another case. Then Prem Shankar Shukla, use of handcuffs. In that list, one judgment is mostly ignored, forgotten, because even CHRI, I credit their organization very highly. They have done a commendable work and they have compiled all these judgments also, but they have also missed, and that is Neel Bati Pera. This case under this gift is sanctioned for compensation under public remedy, apart from the civil, and that is what has made a lot of difference. And this is one case I did not find mentioned here, so I want you to give attention to this particular Ramurthy case, 1997. That gives you all the afflictions that you have in Indian prisons, and that is where he makes an appeal for overhaul of the legislation also. Now, these are some of the judgments which I am sure will get. But my purpose here is to explain to you on the basis of my experience. I may be sounding immodest, but I would like to mention that I have one distinction. I did not start speaking about human rights in Congress. While in service, I believe that one has to work, and one has to work within the confines of law, and one has to succeed. Because many people say that we will give you the results provided to make us free of the shackles of law. No, no democracy, no rule of law will permit you. You have to accept the limitations of law, you have to work, and you have to produce results. I believed in that. My achievements may not have been spectacular, but I have not been a failure either, whether it was Punjab or not. And that is what gave me this respect for law, and which I am sure the community of lawyers appreciate. Now, based on the judgments of the Supreme Court, there is now consensus about the rights of the prisoner. But before that, I want to mention that I have observed that there is lack of clarity about the purpose of prisons. Why are prisons there? There can be four possible answers to this question. One, for punishment and retribution. Second, deterrence. Third, incapacity. He is a savage, dangerous person. He must be caged so that the society is protected. And the fourth, reform and rehabilitation. Now we have social activists, defenders of human rights, and we have people from the establishment. I came across in my experience that both are going extreme views. Whereas the establishment says the purpose of jail is punishment. He has committed an offense, it should be punishment. And the activists say, following what Gandhi said, that the criminal is a diseased mind, he is a patient. The jail must function as a hospital. I feel that it is necessary to drop these extremes and come to the conclusion that the prisons must have all the four purposes: punishment, deterrence, incapacitance, and reform and rehabilitation. Because we cannot lead to a situation where a person is pampered. I always say, treat them gently, see that they get their rights, but at the same time, they must not forget that they have committed an offense. They are here as a result of a procedure established by law and this aspect. So a balanced approach will be the custody and the treatment, and a balance between two aspects of imprisonment. One is the custodial aspect, one the treatment aspect. Now the activists will prioritize the establishment, but a proper reform means balancing the two, and that is what individualization, institutional individualization, treatment and custody both, that is the crux of the reform that is needed. So on that basis, now we say what are the main chief rights of the prisoners. The basic right is, as Mr. Murthy said, right to be treated in a humane manner, consistent with the dignity and worth of this human person. That is what the UN standard minimum say, that is what Mullah Committee say. So this is the foundation, that their human status must be respected and they must be treated humanly. Then there is a right to basic minimum needs, and you must refer to some documents. One is the UN standard minimum needs, then All India Committee, Mullah Committee 1982-83. So they have laid down these scales. Basic needs means accommodation, clothing, bedding, food, healthcare, recreation, exercise, education, training, welfare, work, all these things come in their basic discipline. And what's my experience that when it comes to say accommodation, now NCRP latest report says that overcrowding is 15%, occupancy is 100% national rate. But there are variations because the overcrowding is not evenly distributed. When I started looking after jails in NHRC and I studied 21 states, I started in 1997, the overcrowding was of the order of 35 to 40%. So it is remarkable that it has certainly come down, but still I don't believe that it is 15%, it is more than that. And then uneven distribution, even now, as Mr. Rumoti Deva to my reports about Jharkhand, etc., where I came across places where prisoners sleep in shifts. They work in shifts, we knew it, but they sleep in shifts. Even now, there are places where we have overcrowding in this order. The Supreme Court has appointed, we in our earlier days, we used to have a review district level, SP, DM, and DJ. I would like you to listen to me carefully and discuss this matter. That review, I remember my SP days, was used to be very effective because the three gentlemen would review the cases pending and do it. It became dysfunctional. And now Supreme Court they appointed the review committee. And review committee has not been given the same job. But CHRI has conducted a study and you see what is the state of compliance of this. How many out of 650, how many districts? Not even 300 districts are constituted. And even when they're constituted, are they meeting regularly? And even if they are meeting regularly, is it leading to something? I was a great believer in the fact that no study, no research has any meaning if it does not give an outcome, if it is not action oriented. So whatever you study, whatever you research, it must be linked to some outcome. And see all these review committees, what are they? In this particular problem accommodation, it is still things are very bad. When you talk to the Mr. Sunil Batra here, I used to hold a submission of under trial prisoners separately, convicts separately, to collect information on what are the complaints of under trial prisoners. I will request you to consider this separate. And from Bihar, they used to say that we are not produced before court. And then we are taken. पर हमको बाहर गाड़ी में बैठा के रखते हैं, हमारा बुलावा नहीं आता. And etc. there. So those things are still there. It is happening and overcrowding because there are two chief factors for congestion, which is the root cause of all that affects jail. One, police powers of arrest, which must be controlled. And second, slowness of trial, which is speedy trial part of right to know. And as a result of this, things remain as they are. This video conferencing has been introduced. Have you made an evaluation of that? That is a subject that is done. Then 436A, a revolutionary thing. It changed the laws because of General Khatuna. But what has been impact? My information is the impact has been not substantial, and you might like to discuss it and you might to see what is there. So this, if you can arrest the prison population aspect, then you will be able to do it. The second thing that we consider important is that is right to communication. As I said, that crime is a joint failure of society and individual, and the individual has got to go back to the mainstream society. How he spends his days in prison. So this prison procedures must be consistent with dignity. It must enhance his self-esteem. It must make him a better person. It must equip him with some skill that he is not only willing but also able to live an honest life. And for that, he has to be in contact with his friends, families, and that is communication. And what kind of things we have? You visit any jail, you ask one question, where is the interview gallery? So everywhere you will have interview gallery, a small sketch plan where people don't talk, they shout at each other, packed with visitors and prisoners over 1 meter, say, are to no man land, wars and chicken brush. And when you have people with influence, people with wealth, etc., think what Socio-Legal had there. So all these people, they can avail of whatever facilities, but the poor people. So how interviews are being conducted, that is a very important issue. And how we are keeping them in touch with the families, this is one human right, because despite all things that we say, we have not been able to. The other thing I would like to emphasize is, and that is the recognized, acknowledged human right of prisoners, right to access to law. That means legal aid. And you are lawyers, you know, it is established that this legal right is part of right to life, and a trial will be initiated if it is found that the person was not represented. So we have now at national, state, district level, legal service authorities. But what is the ground reality? I'll be shocking you by giving you my observations. One, I visited Shillong jail in 2002. Till then, nobody in Shillong government knew that there is a provision like free legal aid to the poor, which needs to be operationalized. It was only after the NHRC intervention, after I submitted the report, that it started. Second, wherever I went, I would like to tell me that how many lifers you had, life imprisonment, those who are going. And out of them, how many had their own lawyer and how many were defended by the government lawyer. And I found that most of the people who were there suffering life imprisonment were there as victims of government kindness, because the government provided them with lawyers who were substandard, who were not even mediocre. And Supreme Court has said in one judgment that the lawyers made this free legal aid acts must be of above average category. There is no arrangement. One thing is that pay is legal, payment is legal. Second, no training. Thanks to Mr. Consultant that is thinking of training subject. Otherwise, all these lawyers no. Third, there is no system of evaluation. And that is what I used to do roughly, that how many people are there as a result of the kindness of these people. So until we do that, legal aid is not any relief to the fear. It is some help to those second, third-rate lawyers who are not having good business and the state is providing. You have to see how we do it. Again, one omission in those documents that I mentioned, Sheila per se case has not been mentioned. Sheila per se case is the case about legal aid and mental illness, these 2 points I would like you to consider because that did really make wonderful contribution to this. Now, the next right that I would like you to, that comes the reform is, that is right to rehabilitation of the person. And I just said that a person must come back to good. Just as Venkatacharya was fond of saying, a person goes to prison as an undergraduate and he returns as a doctor, a PhD with crown. And that is exactly what is happening here. The way we are managing prisons, we are creating more criminals and more hardened criminals. So for that purpose, the institutional arrangement is that there should be some vocational training, and vocational training is linked with what? The labor. The labor is as a fun part of punishment through rigorous imprisonment process, and not less. So you should know the difference between RI and SI. SI is there, but if they are willing, then there is no harm, they will do it. And even if under trial prisoners are willing to do some work in village, in jail industry, then if they are welcome, but they will be free. So the first thing is, I want to observe, even in Jaipur and some other good places where these village, jail industries were having excellent standard before independence and even after independence for some time. They were producing tents, but in the jail, it was producing tents for the whole country, tents of excellent quality. Ground sheet, most of the jails were doing. Carpentry, most of the jails were doing. And their products had a market. But over the years, that market is gone, they can't compete. So as a result of that, these factories, these industries are not running to capacity. And raw supply is not, this, the funds are not given for raw material. I found in 5. It has a legal angle. One is you are not giving them work which engages them purposefully. And second, you have done away with the distinction between SI and RI. Because if RI, they are not working, so it doesn't, and wonder what I said, that it will consider as a contempt of court. Because the rigorous imprisonment has been made civil offense, but that is the reality. The other aspect, which is very interesting to find, that is the question of payment. Because Supreme Court has said that when we make people work, it is not a violation of our Article 23, that bonded labor or forced labor, they can do. But they have to be paid. And what they have to be paid? Equitable wages is a crime. I think 4 or 5 years back, NHRC conducted a workshop and I was invited. I had left NHRC, but I came. I found there that one respectable, the honorable member of the NHRC was asking each representative from each state to confirm that the prisoners are getting minimum wages. And whether it was a coercion or persuasion, everybody was saying, we are giving minimum wages, we are giving minimum wages. I got up and I challenged this. I said, where is it written that you give? I want you to take up this issue in discussion and study in detail. There was a judgment of Himachal Pradesh High Court in the 70s. It said that the prisoners should be given minimum wages. Then this judgment was delivered by Kerala High Court also. Then the same judgment with Tamil Nadu there also. And finally, Gujarat High Court also, that prisoners should be paid minimum wages. So people said people are not getting minimum wages outside. And if you give, ensure minimum wages, so is it not an incentive for them to go to the promised land, that is prisons in India? And then Gujarat government went in appeal, and in 1998, the Supreme Court finally settled it. And they made it very clear, they nowhere said minimum wages. They said equitable wages. They said every state must have a wage fixation committee. The existing rates at that time were 5 rupees unskilled, 10 rupees semi-skilled, 15 rupees skilled. And as a result of this judgment, within the 2 years or so, everywhere the wages became 30, 40, 50. That is substantial. But nowhere can you give minimum wages in Delhi now with 550 rupees. 500 rupees. Who can afford it? So we should make clear. It's just like, you see, when Shankar Shukla judgment, police officers don't read the whole judgment and say that Supreme Court has taken away power of police to arrest, to put handcuff. Nowhere they said it. In the concluding power, they said that record a note and see 1, 2, 3 reasons why you are finding it. But the policeman find for a dig to record all that. He wants to do things arbitrarily without question. But if they read these judgments of the Supreme Court clearly, there is no vagueness, no confusion. So in this case, it is settled that these are everywhere wages should be equitable, wages should be revised periodically. And one more point that has come through this judgment, which is a real reform, and that is they said that government should consider the possibility of giving a portion of earnings of the prisoner to the victim family. So that means whatever he earns as a result of what? A part of it, say 25%, is meant for the deserving victim family. If the family is rich enough to afford not to need it, no point. But poor people, you know what has happened? Go and check it if you want to study. Tamil Nadu, Madhya Pradesh, Bihar, and Delhi, and couple states. The amount has been deducted from the prisoner's wages for this purpose, and it runs in crores. And since I am from the police and BSF and CRP have worked there we create non-official funds which are beyond audit, which give us enormous opportunity to misuse them. In all these states I mentioned, the real disbursement of this has not started. So let this be a study that how much amount Tamil Nadu has collected over the last 20 years or so, how much. There is a mechanism a committee headed by DC would look into the background of the victim family, needs, etc., and give substantial amount, not just the only the wedding of a victim's daughter, so you can give money. That money is lying there, but that money is not being used. That's the point I wanted to make. So, one interesting case I tell you, in Himachal Pradesh, I came across a doctor. He had murdered his wife. He was undergoing life imprisonment. He had a room given to him. Why? Because those Supreme Court has said that there should be new classification of prisoners, not the earlier category. In the earlier category of prisoners, there was one category, addicted to superior mode of living. And when you are addicted to superior mode of living, the doctor he got a room. So he had the computer installed there, he had a TV there, and surprisingly, he had a domestic help. One prisoner was working as his helper there. Now when I talked to this prisoner, and I said, do you like it? He was immensely happy with this agreement. Why? He was getting minimum wages, because that was the time when Himachal Pradesh had enforced. So the doctor was having all these facilities, that fellow was having 70 rupees and 80 rupees a day. And this is the actual reality that is finding out. See, NHRC has been concerned about it. NHRC is mandated under Section 11 to look into it. NHRC has succeeded in getting the Act amended as regards jail, because the earlier version said that we have to seek permission from the state government, and now surprise visits are allowed. So this has been a very effective action of the NHRC doing. NHRC did one thing remarkable, but it has not been taken to the logical. That was that since we are still being governed, the jail, by the 1894 Act. And this Act emphasizes what? Discipline, control, authority, powers, offenses. It nowhere mentions rights. It nowhere mentions torture as an offense committed by staff. They know what kind of offenses can be committed by the staff. They nowhere mention torture. It was beyond the imagination, then anybody would be tortured. So the NHRC, they did what approval. They prepared a draft act, new, enormous, by taking help from experts, and it was forwarded to the government to all the states. But what has happened? As a result of this and Mullah commitment, jail manual has been revised. And that manual, despite some flaws, in fact, I still welcome it, because it has taken care, it has improved. But the manual derives authority from the law, from an act. So act is a primary, manual is rules. So the act has not been enacted. The act has not been. So I request this university to take up this issue. The whole thing is ready. And Delhi police, Delhi prison have made an act on that. Kerala has made an act. And Punjab dropped the act. So 3 or 4. So somebody should study what the NHRC did down, what they have done, and come with an act. This is a lacuna, shameful lacuna for a country like ours, that we still do not have a modern act which can respond to the new emerging conditions and aspirations of people, and that is what is required. So I would like to conclude now, because I'm glad that I call him headmaster, Mr. Gonsalves, so particular about time, I respect. So I would conclude by saying two things, as Mr. Murthy said. But before that, I would say my experience told me that jails will improve where 2 conditions are satisfied. One, the DJ or his representative visits jail regularly. My reports about Tamil Nadu, my reports on state, I clearly brought up where these officers of the judiciary are visiting regularly, things are not very bad. And second, access given to NGOs. So where NGOs are allowed, communitarian approach, that they cannot go to the community like community. NGOs can do wonderful work in education, in training, in drug addiction, in vocational training, in placement, in looking after children who are outside. And in the art, they have involved NGOs in a big way. So if we can, but NGOs, we have to be very careful. There are NGOs and NGOs. I got one NGO blacklisted Because he wrote to me something report. I appreciate it. The way I am constituted, I immediately wrote a letter of congratulations. You know what he did? He framed my letter and he put it on the wall in his office and he started extracting money from superintendent. I'm very close to Mr. Chamala. I can help you in trouble. And I have to get that. Because we have to be very careful when it comes to NGO sector. But I am a great believer that NGOs, civil society, as Mr. Ruti said, that quoting the level of civilization, the quality of the criminal justice system is the most reliable measure of the level of civilization of the community. How we treat, and Nelson Mandela said it, a nation should be treated, should be judged not on the basis of how it gets the highest but the lowest one. And this has been adopted as Nelson Mandela UN rule now. So this gives us a clear idea. I'll conclude by saying that we should be very clear and a balanced thing that we should have. When it comes to, I'm sure you will be discussing reforms in detail, the scientific classification is very important. The balancing of custody and treatment is very important. Then the enhancement. And the most important thing is that Justice Verma, just 2 minutes, Justice Verma used to say, what will you do even if all the reforms have been sanctioned? Until you get address your internal infirmities. Because that's subculture, internal infirmities. And that means plight of the keepers. What is the status of the prison person? They are highly demotivated. I said ill-paid. They are not recognized. They wear ranks equivalent to police, but they are far below in terms of pay and perks, etc. So that's why they do not respect rights. Because rights come as a threat to them. They feel disempowered. And since they cannot cope with the stressful conditions, they take it out of business. And one thing which is most objectionable, nowhere I found mentioned, you must discuss. Still we are using convicts as convicted guards. We are using gang leaders to control others. This practice is there because of shortage of manpower and other things. So we have to see what are the conditions there. And their housing conditions, the poor conditions. And the other agencies, police, judiciary, they treat them shabbily. They consider them as managers of the dustbin of the society. That is what the state is. So until we give them recognition, respect for what they're doing, and tell them that this is a social service, that this is a moral endeavor, this is not just a livelihood thing, that you are there to elevate the suffering. That kind of attitude they have done. And that will be the greatest reform if we can. Thank you very much. And sorry if I take it
questions, observations,
Yes.
very easy to address Mr. Chamala. Please raise your hand and
Sir, what is your observation on rehabilitation in prison? And sir, I have seen that most of the prisons are not properly working on it. Sir, how could you suggest? And
Yes. You see, that is what I said. Even NHRC, when they listed rights of the prisoners, they listed the first 3. The rehabilitation, they did not list the right. Because they also felt that if we make it a right and stay, because states are not. But now increasingly, because Supreme Court has said in one of the judgments that this is a right, fundamental right of the prisoner. So they have to develop facilities. And one way is, can we involve private sector? So in Himachal Pradesh, what they have done, that they allowed one bulb manufacturer to open a shop in the jail premises. And prisoners work there. And they get handsome wages. And then, so there are ways. But don't extend it to the idea which is being done of privatization of jails. Never. Because that will issue question on legitimacy, accountability, responsibility. But this kind of thing, that if we can develop facilities inside the jail, taking help. And secondly, there are other ways. We have several government programs. For example, say Anganwadi in West Bengal, what they do, they established one Anganwadi center there under that scheme. So there are so many schemes, it's a question of having people with imagination to say that this kind of project can be taken up by the jail and the jail staff. So it is possible, but there is no option. We have to do it. As I said, otherwise the distinction between simple imprisonment and rigorous imprisonment is gone. So that must be developed.
This is Raja from Tamil Nadu. As I understood that you are a former IPS officer, so I want to have your impression that I have a great difficulty to understand who is a police officer, who is a prison officer, because all are having same color of uniform and their mentality also is the same. Because prison officer is supposed to work as a reformation officer. Since they have the similar dress code, they are acting as a police inside the prison. So that is my question. What do you think about to change the colors of the prison officers, the uniform? What is your impression?
Very good question. I always felt that prison service should be taken separately. And I was of the view that they should have prison officers at all levels. Whereas in some states, even jail superintendents are being supplied from STML sector. So there would be complete. And the prison officers must be allowed to rise to the highest level, at least say IPS sector. And uniform also, my personal view is should be. Because the question of maintaining this distinction. For example, we should, for example, when you are releasing a person, you are not required to obtain a report from police, but still some states are doing it, which is wrong. You are probationary officers, you should lose them. So this kind of separation is desirable, necessary, and that would enhance the esteem of jail and correspondingly the pay, wages, etc. should also be improved.
My first question is, what do you think of the concept of open prisons? Do you think it is a way of rehabilitating the society?
The Supreme Court has repeatedly said that reforms means liberal parole provision, open jail, greater frequency of meeting, and access to law court violence. So open jail I have studied in Rajasthan, Jaipur. Rajasthan created a good example. I studied in Bilaspur in Himachal Pradesh. I studied in Karnataka. I studied in Kerala. They are excellent institutions. They are working very well. But question is selection of the inmates. So after they have completed, say, 5 years, whatever they're there, and their conduct, and then control them, it has helped everywhere. It has not led to any scandal. And I would like to say that when we talk about reform, we say individualization of treatment. We have 3 categories of prisons, friends: high security, medium security, low security. Should we send everybody to high security? As we in Punjab, I saw that terrorists arrested in Bilaspur were not sent to Ropar, which was a high security, because if they go there, they will be indoctrinated by Bindra. And if they stay elsewhere, they will not. So here also, we have to see that a man does not need high security, he may need lower security. And that is the idea of open jail, which is being
I just wanted to move from uniforms to uniformity. We have been harping upon uniform civil code, uniformity, legal policies. How about uniform jail manuals, sir? Why should there be a discrimination? Some jail manuals with better reformative policies, some with little less reformative policies. So, sir, your thought on that?
I covered it in my talk when I said the NHRC realized that all states have varying standards, particularly varying standards with the Sunil Batra will appreciate about the release of lifers. In some states after 14 years, in some states 18 years, Maharashtra 30 years. So NHRC gave this idea that there should be one manual, one law. And they give a draft also. So I said that once that law is built, based on that law, there should be one manual which must control. Now parole, I long political parole for 3 years. Can you believe in this kind of thing? Then it will have parole, remission, wages uniform. It's very desirable, and that would be in reform. Otherwise, it's I hope actually work that way.
I'm going to make this very short because we need to keep time for a good round of questions and answers towards the end. Well, my experience of having worked in prisons in Maharashtra has been near close to 3 decades now. I've been working and associated with this project called Prayas, which is a field action project of TISS, Center for Criminology and Justice, and which has been working in prisons in Maharashtra and Gujarat for the last many years. So let me just flag some of the issues and then we can later on have some questions. I'm only going to flag them. The first and important point that we need to look at when we are looking at Maharashtra, as would be the case with most other prisons in the country, is the issue of overcrowding. And this is particularly a problem in the big cities and towns. So when we're looking at Mumbai, Thane, Pune, Nasik, some of the other major cities, the prisons are overcrowded to up to 3 times. So if you look at Mumbai Central Prison, which is the Arthur Road Jail, the population is about 900 by official capacity, but you have nearly 3,000 prisoners. And that's the case in all the other major prisons in the state. So that is the major issue that we are looking at when it comes to prison conditions. That has an impact on all the other facilities that prisoners are supposed to get. Similarly, the issue of under-trials. So despite all the efforts made by the Supreme Court, the High Courts, the prison officials, the departments, the situation continues to be that 70% are under-trials. So for example, in Maharashtra, as of now, there are about 30,000 prisoners, out of which more than 20,000 are under trials. So that's the given reality. The second point that I'd like to make is the issue of access to legal aid. And this is absolutely crucial. If we are going to focus on the issue of overcrowding, the only way, in my opinion, that this issue can be dealt with is if we do something when it comes to the issue of access to legal aid. And we all know that this is a real problem across the country. And the real reason behind it is, in my opinion, the fact that the honorarium that is paid to legal aid lawyers is extremely poor. And until and unless we have a system whereby lawyers are paid a robust honorarium, we are not going to be able to improve the situation of legal aid in the country. Our involvement in a PIL recently in 2014 on the situation of children of women prisoners left outside. It's a PIL called Sonepat PIL 107 of 2014 Bombay High Court. Has through that PIL, the honorarium for legal aid lawyers was increased to now it is 7,500 per case at the lower courts and a maximum of 750 rupees per hearing for an effective hearing. In our opinion, this is also very less. Earlier it was 1,200 rupees for an entire case. So, if we are really serious about overcrowding, we have to attack the issue of a good honorarium which is to be paid, and along with it goes the fact that there has to be a very simple procedure to claim that legal aid. Because for many of the lawyers, they have to wait till the entire case is over, and then the magistrate has to submit a certificate saying that he or she has appeared in this matter, and only then the honorarium is paid to this lawyer. So, this is a real issue that I am trying to flag here. Similarly, there are provisions for legal aid lawyers to come inside the prison for legal guidance work. Maharashtra has a very good law called Maharashtra Visits to Jails and Children's Homes Project Rules 1993, under which duty counsels are supposed to be appointed. These duty counsels are lawyers with 3 to 5 years of experience, and they are supposed to visit the jails at least once a week to identify people who need legal access. Again, the problem is that duty counsels are there, the roster is there are lawyers who are supposed to be going, but the honorarium used to be 60 rupees per visit. It has recently been increased to 500 rupees per visit. Even that is really less if we really want lawyers to come in. The third point I'd like to mention is the issue of health. Health and mental health is a serious problem in prisons. Many of the posts are lying vacant. The health department is not filling up those posts, including posts of psychiatrists, etc. Recently, through a prison reforms committee set up under the orders of the Bombay High Court, which was chaired by Justice Radhakrishnan, retired. I was a member of that committee. We have come up with a provision whereby the Department of Health Services has issued a circular that the nearest civil hospital will start a local OPD once a week, where a general practitioner, a psychiatrist, a pediatrician, a gynecologist, and a skin specialist would visit the prison once a week and would provide medical services to the doctors, because the problem of escorts is so serious. The prisoners are not able to be taken on their court dates or to hospitals when they have to be taken. The fourth point I'd like to mention is the issue of video conferencing. Prisoners are being produced through video conferencing, but there is no legal support for them in prison. And there is a Bombay High Court judgment which talks about the fact that there has to be legal aid lawyers present in jail when the prisoners are being produced through video conferencing. The last point that I'd like to make is the issue of staff vacancies in prison department. It's as high as 30 to 40% across the country, and nothing. The situation is the same in Maharashtra also. And because of this, there's tremendous stress. Prison officers are working more than 12 hours a day, and their working conditions are really bad.
I'll make a very quick presentation. So basically, part of our mandate under Section 10(1)(k), the Commission inspects custodial homes, remand homes, and other institutional care settings where women are kept as prisoners or otherwise. So basically, we try to study the conditions and facilities available to these women inmates in jails or other custodial or institutional care settings. After our observations are framed, we forward our recommendations to the concerned authorities like the DGP, the IG, as well as to the concerned jail superintendent. So whenever we forward our recommendations, we always ask them for an action taken report. And we analyze those action taken reports, like whatever action they have taken on the recommendations we have suggested to them, and we monitor the progress from time to time, and there's always a follow-up. So for this inspection of jails, we have developed a very comprehensive performer, detailed and comprehensive performer. Like Commission has been inspecting jails since I think its inception 25 years ago, but the performer was not very well at that point of time. So we have developed a very detailed and a comprehensive performer last year. And I'll just share like what mainly are the parameters we are trying to judge for that performer, like the infrastructure, the healthcare facilities, skill development training, welfare activities which the jail is undertaking, and the availability of legal safeguards. And apart from all these parameters, we also have a set of like 84 open-ended questions which we are trying to map to the performer. The performer is available on our website, and it is available both in Hindi and English, and we are trying to also translate it into the regional languages. So whenever we go and inspect the jails, there's a certain inspection committee we have formed. So there'll be our chairperson or member from the Commission or the officials of NCW. Then there'll be one representative from the State Commission for Women, one representative from the District or State Legal Services Authority, and a social worker, mental health social worker, psychiatrist, or a psychologist. So the Commission has come to a decision that, of course, there's so many jails in the country where women are housed. So we are basically mapping the central jails, and we have asked the state commissions to do the district and sub jails. So now I'll move on to the performer. Like we have shared the performer with all the DGPs and the concerned jail, other jail superintendents and concerned jail authorities, because of course we can't go and to each and every jail. So based on this performer, I have to share certain observations with you now. So if you ask me कि एक जो जेल में महिला बंद है वो कौन है? So mostly what we observe the pattern is mostly the women are between the range of 18 to 44 years. Of course, there are considerable amount of women who are above the age of 60 as well. She's an illiterate woman, she's married, and she's a housewife. And the charges against her are mostly murder, dowry and domestic violence, and NDPS Act. So now the categories I shared with you, like how we are trying to map through our performer, is like vacancy. So we've seen there's a lot of shortage of staff owing to vacant positions, and we are trying to map the vacant positions right from sanction posts to ad hoc and contractual vacancies. But the trend we are seeing is like there is a major shortage of staff, and especially when it comes to, as Sir also mentioned, medical staff is like a big shortage. Like there are hardly doctors, and even like you see my second point, it's like 90% of male staff is recruited against the sanction post. So even if you see, there are not even availability of female doctors as well. Then as far as infrastructure is concerned, they're good in some jails while average in most. And this average comment is mentioned by the jail authorities themselves. So like when we are calling, if we can't go and inspect a particular jail, we are also calling in performers from these jail authorities. So they have themselves mentioned either poor or average structural conditions. Then overcrowding. Overcrowding we've not seen so much in the central jails, but yes, district jails is a major overcrowding and it's more than, I can say 100%. So like if there are the capacities for 26 inmates, there are 84 inmates. Then of course the healthcare facilities are totally in a dismal state. There is totally non-availability of healthcare professionals, psychiatrists, counselors, social workers. There's total absence of female specialist doctors. And a lot of inmates, when we talk to them, they have actually asked us that they need a gynecologist. Or even for that matter, they specifically asked and made a request that they need a female doctor. Then the health cards are not maintained. Whenever there's when an inmate is brought into the jail, though the checkup is taken, but there is no proper health card being maintained. Then vaccinations are not administered to both the females as well as the females. Some are pregnant, some are lactating, so they need certain specific medications, and vaccinations are not being provided to them, nor to their children. The medical staff is not available round the clock, and there's a lot of dependency on the paramedical staff. They don't even have female nurses available round the clock. Then regarding the welfare measures, this is also seen as a trend most in the district jails. Like common areas such as prayer room, vocation room, facilities such as school, creche, etc. are not made available. There's a total lack of recreational activities. There is no roadmap in the sense prepared that what are the jail authorities doing to improve the living conditions of these women. There is no initiative to make the inmates' children familiar with the outside world. There is absence of adult literacy classes in most jails, which again are talking about district and sub jails. With regard to vocational self-development training, of course, there's a lack of diverse educational, vocational, and other programs as available in men's prison. The programs tend to, of course, reflect stereotypical female occupations, and most of the district and sub-jails are not providing certificates after, if a woman goes under any kind of skill development training. With regard to availability of legal safeguards, legal awareness programs are organized regularly in all the jails mostly. But there is a lot of lack of satisfaction on part of the inmates when it comes to legal counsel. Availability of legal counsel, both the legal aid and otherwise. In some cases, the inmates have reported DLS advocates demanding money from them, like many in fact. Video conferencing facilities available in most jails, and the inmates have confirmed that they are able to access it. And then there are certain general observations we have made, which are like inmates with special needs, like physically challenged, mentally challenged, pregnant, lactating women are all not kept separately. They are all housed together, especially when it comes to physically and mentally challenged inmates. The number of sanitary napkin packets provided to them are not adequate. Like they have just provided one sanitary napkin in 1 month, and it is not enough for them. Then there is no exclusive kitchen or kitchen garden available to them. They have to be totally dependent on the male jail for that. Hot water facility is not available, and this trend we have mostly seen in the northern regions like JNK, UP and all. The hot water facility is not available in winters. The jail staff is not really handling the women with special cases or special needs. There is less involvement of civil society and NGO. Whatever NGO and civil society who are engaged with the women in prisons, we are seeing it's like art of living and all. So there is no concrete as such NGO involvement who can help them out. Then, of course, the judgmental attitude of the staff. Like in the performer, we've purposefully not spoken about or not asked for socio-economic and religion or even caste-based information. But in the jails, women have told that based on the kind of crime they have committed or the socio-economic background, there is a lot of discrimination among them. Well, as far as recommendations are concerned, I think we have been really talking about a lot of recommendations in the past, and I think today also a lot of recommendations will be spoken about. So I would just like to skip, but one or of some of the recommendations which have not been really highlighted of late is like there are a lot of inmates who are literate or they are somehow trained in certain skill. So why should we not promote them to teach the other inmates? They'll also get involved. And with regard to the medical facilities, we have another recommendations like intern and residents of medical colleges in the vicinity could attend to the inmates. If you're just depending on the doctors, they're not available, of course. That's what the health department always says to us. So it's better why don't you indulge all the interns and residents of medical colleges available around and involve them in the prison. And of course, a comprehensive aftercare program is being stressed by us, We're also preparing a document based on that, that how can women be again mainstreamed back into the society. So we are working on it, and as I said, our performer is available online, so you can actually see the performer and give us a feedback if you think anything is there. Thank you.
So I am working as a project officer with the Commonwealth Human Rights Initiative with their prison reforms program. Before I come to my area that I'll be speaking on, I would like to mention that, some of CHRI's report, particularly on prison conditions of different states that they've done, starting with the condition of prison oversight mechanisms in prisons of Andhra Pradesh, a study that was done in 2006, and other studies that you can access from our website. These studies also involve studying the sub-jails, the apathetic condition of sub-jails in Maharashtra. One of the major recommendations from that report was transferring the administrative setup of sub-jails from the revenue department to the home department. So Maharashtra is one of the few states in India where the sub-jails are about 100 sub-jails that are there in Maharashtra are under the revenue department and not the home department, which also leads to their apathetic condition, which is still existing. So in my presentation, I'll be mainly focusing on prisons of Haryana. This study is basically still underway, and this study was, we are conducting this study as a part of the PIL that is going on in the Supreme Court right now, which is Re-Inhuman Conditions in 1382 prisons. So this study was sanctioned by the Haryana State Legal Services Authority, and as a part of this, we tried to study the overall conditions of all the 19 prisons of Haryana. So there are about 16 district prisons and 3 central prisons in Haryana. Surprisingly, Haryana is one of those few states with minimal overcrowding, which is about 10% overcrowding. Although, as Sir also mentioned, as Professor Raghavan mentioned, large number of percentage of under-trial prisoners, which was also there in Haryana, which was slightly less than the national average. About 62.7% under-trial prisoners are there in Haryana. When it comes to overcrowding, which is 10%, but I would like to reiterate what Chamanlal Sir said about the uneven distribution of uneven overcrowding among when it comes to uneven overcrowding among states in India, which was also the case we saw in among the districts of Haryana. Although most of the prisons were undercrowded, but some of the prisons like Rewari, which was smaller in smaller jail complexes, had overcrowding as high as 40 to 50%. So that was one aspect that we saw these are some of the statistics from the capacity of inmates, etc. Few issues that I would be highlighting, major issues that I would like to highlight from the study that we have observed through our field visits in all the jails. One major issue is that there are no women jails, no separate women jails in Haryana. So women are housed in complexes meant for both male and female in smaller separate sections in male complexes, which also leads to, as Avni also mentioned, also leads to their neglected state, which is also common in other states of India. I would then like to focus on the condition of medical healthcare in the jails of Haryana. Although surprisingly, there were when it came to infrastructural developments of healthcare, like availability of separate hospitals inside jails, availability of ambulances, etc., all that was existing. But when it came to specialized medical officers, that was a real lack which we observed. Doctors like gynecologists, female doctors, psychologists, psychiatrists were not there, dermatologists, etc. were not there, and mostly the common diseases that are prevalent in all the jails are skin diseases as well as drug addiction, but there are no rehab facilities also in Haryana. That is something which is really lacking. Another stark feature that we observed in almost all the jails was confinement of juveniles. Juveniles as young as 14 years were being confined in many prisons of Haryana. So we interviewed around 35 juveniles and we individually tried to pursue their cases so that they could be transferred to observation homes from there. There was a clear lack of legal aid knowledge among inmates. Legal aid knowledge as well as with regard to specific provisions of legal aid, also also the provisions of jail lok adalats. So although jail lok adalats were being conducted in Haryana regularly every month by specific DLSAs, but inmates were not really aware about what are the provisions of jail lok adalats. Another specific issue that we found out from our visits was the mandatory, or I should say forceful use of Aadhaar card that was being carried out. So for things like opening of accounts for convicted inmates, families when they visited for mulaqats, or even access to canteens, for all these provisions Aadhaar has been made mandatory. It is, I would like to highlight, it is especially difficult for inmates coming from lodged in Haryana jails who are actually residents of other states like Bihar, Jharkhand, etc. They have minimal family contact, and when it came to they've been inside prison, and not all the prisons have provisions for making Aadhaar cards from inside. So they kind of really suffered when it came to enjoying the facilities that they are entitled to inside the prison. Apart from the issues, I would really like to highlight some of the good practices that I can term good practices that were being followed, and some of them also surprised us when we visited. One is Haryana has this. Haryana is, I think, the only state in the country that is following its own. One of the convicted inmates developed this software called Phoenix. So this software is being used as a database for storing information of prisoners, their remission, the parole, etc. And it was developed by a convict from Gurgaon jail, and it is being used now in all the jails of Haryana. Another was the prison infrastructure. Haryana, as a part of prison modernization in mid-2000, Haryana really invested in revamping their prisons. So, if you enter the prison, you are the first thing that you notice is the vast area, green cover that Haryana prisons have. They are spacious. There's less overcrowding, and they are also investing to curb that 10% overcrowding. They are also building new prisons now in states like Palwal, Panipat, etc. There's a very active canteen facility, and the canteen facility has been made cashless. So there's no cash involved. It's all through cashless card system, and inmates can take the facility through. All the items are priced on MRP or less than that. Another thing that I would like to highlight, since there's less time, I would just highlight one more aspect, which is the mulaqat system in Haryana. So although they follow a intercom system where the family is on the other side, the inmate is on this side, but the infrastructure of that, the mulaqat area is really good. The family and the inmates are divided with a glass wall. They can talk through intercom, but the areas are under CCTV surveillance. There are places to sit for inmates and the families, and at times these are also air conditioned. So these are some of the good practices. I would also like to just mention briefly that I've worked for 2 years trying to explore the role of social worker in Aligarh district prison. So that really helped me in conducting the study in Haryana. So although things are very different in UP prisons as compared to Haryana prisons, in UP there's extreme overcrowding, but there are some good aspects there as well. So it was a good experience studying the district prison and prisons of all the prisons of a state. For the lawyers who are present here, I would really like to just mention that there's a lot that lawyers can do, take a proactive role among other things, and really act as a link between the judiciary and the prisoners. So yeah, some of the things that I've highlighted in the PPT I won't mention because the time is limited. So yeah, that's that. Thank you.
Thank you. Ask questions about the court case, for how long they've been inside, their legal representation, in addition to what problems they're facing in prisons. Additionally, we are also looking at the prison infrastructure and prison hospital, prison kitchen. We also talk to the prison staff and try to get their view about what they feel about the problems in prison and what their situation is. So, some CGM or ACGM visited the prisons with us so that the report can be called a government report so that it has some validity in courts. I'll just share what basic problems we found during this inspection. The first problem is of infrastructure. What Mr. Chamalal said, old prison buildings, like there was no light inside, old buildings, it seems like you are in a horror movie. Scary prisons inside, no lights, you have to sleep on floor, damp walls, toilets are almost broken, there are no fans, dysfunctional toilets. Another part was that when we were doing this inspection, there was this earthquake in Bihar. I'm sure you would have heard about that earthquake in 2015. So we were in a courtroom meeting with the district judge regarding the prison inspection. And then there was this earthquake. And suddenly the district judge runs out, we all ran out, but all the inmates who were in the court lockups, none were allowed out, and they were shouting inside that please let us out. Because when you all are running out, we are scared for our life, but what about us? But no one cared for them. They were inside. Later on, again there were tremors because aftershocks are there. Second aftershock was there. Again they were not let out. That time we were in the Pune Central Jail. So we raised the issue with the superintendent saying, "If this is the condition, if something happens and some inmates die, who will be responsible for that?" So the superintendent said, "We don't have any orders from you. There is no plan in Bihar to deal with such issues. But on my part, what I do is I will allow the locks to be open at the night at my own risk, because if some inmate flees and something happens, I will be suspended." So that night they allowed the doors to be open, but they forced the inmates to be inside. Again there were tremors that night. One of the inmates jumped and his feet bone was broken. So this is the condition. There is no plan to deal with exigencies like fire, earthquake, or something happens inside. It's just running the same way, same Bhagwan Bharosa. So that way it's going on. Another issue, again we have already discussed, is the access to justice. Access to justice means legal aid. The legal aid system is worse. When we were doing the inspection in Maharashtra, they pay 7,000 rupees. In Bihar, they pay 800 for a complete trial. You go for 5 days, you will be paid 800 rupees. I don't know the current rate, but it was 3 years ago. So I don't know any lawyer is going to take up the case or not. Anyone who doesn't have any case only takes up the cases. There is no proper mechanism for mulaqat system. Again, Mr. Chamalal had already mentioned it. The same system is there. There is this 1 meter gap. There is a net one side, there is a net this side, and it's not an individual prisoners will start. The list goes, if 20 or 30 prisoners are asked to come in, they stand on one side, 20 or 30 people stand on one side and they shout at the top of their voice. So you shout from both sides, someone hears, that's the only way of communication and mulaqat. And for most of the lawyers, this is the system. There is no specific room where private lawyers can go and sit and talk. So this way the system goes on. The third problem is of court production. I don't know about other states, but this is a very big issue in Bihar. It's going on right now also. Half the times inmates are taken to the court. If you are an under trial prisoner and no witness has come or charge sheet has not been framed, this one system procedure, you are not taken before the magistrate, in front of the magistrate. Someone comes, gets your sign, goes back, and that's it. And what importance court production is, I'm sure the lawyers know. If you have some torture in prison, you have a lawyer or not, all the things magistrate is supposed to ask. Lots of cases, the court has said that this needs to be enforced properly, Supreme Court, but nothing has happened on this aspect. In case of women inmates, there are some special problems. First was that in all the prisons in Bihar, most of the prisons there is a hospital. There is a hospital ward at Christian Central Jail and district jails. But for women, there is no hospital. Like if someone is sick, they are supposed to stay in their ward. Some male doctor will go and give some medicine. Even if say you need to be, given some medicine or injections, you have to stay inside. Males will go to the prison and they will be given a bed and all. But for women, no system was there. There were no lady doctors. There were only 6 lady doctors, women doctors in Bihar prisons, and none of them were posted in women-specific prisons. I even found that one gynecologist was posted in a male-only prison. Another problem with women in prisons of Bihar faces this social ostracism.
because see, you are from a backward community mostly. So when you go to jail, you are not you are a non-voting member of the family. So after some time, the family members forget you because they don't have the money. No one can continuously come and visit you. And when we ask them in the prison, do you have a lawyer? Only response is, "हमारे guardian जानते हो." Guardian is the word for the husbands or the family members. So they don't even know what case they are in. Most of them, they didn't know what was the situation, whether they have a lawyer or not. Health issues outside also hospital facilities are bad. So inside prison, I don't know what to expect. Medicines only paracetamol and D-complex generally we found in most of the in the prison hospitals. X-rays, where there in several prisons, but none of them were working. The HIV kits are required under this prisoner screening form. And some prisoner is first time got to the prison, will be knowing that they are supposed to ask them some questions and check them for their disease. Say if someone has TB, HIV, or someone is suffering from some disease. So they are supposed to screen. None of the kits are available. They just asked, "Aapko HIV hai?" They said no. "Aapko TB hai?" No. That's it. That was the thing followed. Almost no doctors were there. The compounders did this thing also. Another issue was of remissions and prison punishments. Remission was stopped because of this Morgan case in Supreme Court. Supreme Court had stated it was settled later on. After the report came out, we started litigation on these issues. We filed first of the case. We decided that we will file cases separately on the issues because when a common PI is one of my experience and some of my colleagues suggested, most of the issues are not taken up in the court. So we filed a case asking for hospitals and prisons. The state filed a counter affidavit, and all the issues raised in our report, they fulfilled all. They said we have taken these actions on this. The counter affidavit is there. If anyone wants, I can show it to you. They conceded to all our demands except one. That is the access to justice part regarding legal aid and court production. They didn't mention it in the report. We filed another PI regarding especially this issue. Court disposed it off, saying you just approached Barasa and this is a non-issue. We went to Supreme Court, while presented us there. Supreme Court said you need to decide it specifically because they are very important issues. Again, pending in High Court. Let's hope that court production can be settled.
I'm Tapan and today I will be discussing the conditions regarding the prisons in Uttar Pradesh. So basically, I had worked as a criminal justice fellow from 2016 to 2018 in Uttar Pradesh in 3 district prisons, that is Bhubaneswar, Aligarh and Gautam Budh Nagar. So I had worked on like 2-3 issues there, and I'll be discussing them only. And secondly, I have been working with Sarkar Nagrik Sangathan as a legal consultant that is working towards the implementation of RTI Act. So I'll start discussing like the conditions of prisons in Uttar Pradesh basically. So I'll be discussing the facts related to the prisons in Uttar Pradesh, the issues that I identified during my visits and work, the obstacles faced by me, and the suggestions that I will be putting forward. So basically, to give a quick review of recap of my work, basically I worked in 3 district prisons, Bhubaneswar, Aligarh and Gautam Budh Nagar. The first issue that I worked is the issue of legal aid, that is very much normal when you are working with a prison. So the work included like identification of the prisoners who are in need of the legal aid and like the forwarding the matters to DLC. The second issue that I identified during my course of work was the issue of bail. This was an important issue since I was a lawyer and I had to work on the issue. So, as a matter of interaction with the prisoners, I identified cases where the prisoners must have been granted bail, but due to lack of legal awareness or lack of legal counsel, they were not being given the right to bail. So I worked on that issue, and like I used to file bail applications for them. Even if they had like previously they had let's say they had got the bail done and they were still in bail due to lack of sureties and such other reasons, I used to file the reduction of bail sureties application for them. The third issue that I worked was basically the improvement of medical facilities. As everyone is aware and other people have already said that the medical facilities inside the prison are really bad. So I had worked on the issue, so like setting up of medical camps inside the prisons with different stakeholders, like collaborating with the medical association of the districts or like contacting the local medical colleges.
So in that way, I used to set up medical camps inside the 3 district prisons. So basically, like I would like to show you some of the facts relating to the Uttar Pradesh prison. So these records are all have been taken from the UP prison official website, and the prison population according to them is around 96,000. So the occupancy rate, that is the overcrowding thing, is like almost 1.7 times the actual strength of the prison that is concerned in Uttar Pradesh. So this is the average of Uttar Pradesh. But like I worked in 3 district prisons, now I would like to highlight the overcrowding in these 3 district prisons. So as you can see from the data, Bulandshahr district prison has around like the overcrowding rate of around 2.2%. Basically 2.2 times they have overcrowding rate, and the undertrial population in that overall population is around 73%, which is 2% more than the general average of Uttar Pradesh. The second prison is like Aligarh. Aligarh district prison has almost 3 times the occupancy rate. Like, the official strength is around 1200, and the actual strength is more than around 3500. So that shows the amount of overcrowding in that jail. And apart from that, 80% of the population in Aligarh district jail is under-trial population. That is far more than the state average of Uttar Pradesh. The third prison, Gautam Buddha Nagar prison, it contradicts the other 2 prisons that I have worked. So the official strength is more, and the actual population is a little, very much less. That is, overcrowding is not there, and the actual population is a little bit less than the official, very much less than the official strength. That is because Gautam Buddha Nagar, that is Noida, that is a newly constructed prison. So the official strength is also more there, plus the present population is limited. But I would like to point out that the under-trial population of Gautam Buddha Nagar prison is 91%. Like, that is around 20% more than the under-trial population of the state average, that is 71%. So these are basically some of the data. So we can like infer from the data only that how much overcrowding is specific to these prisons, and that is more than the state average. Since I have worked with like improving the medical facilities in the prison, so I would like to point out the official strength and of doctors and prison staff also in the Uttar Pradesh prisons. So the prison staff is like short by around 1/3 of the posts that are sanctioned by the government. Like around 3,000 posts are vacant for the prison staff, and already the prisons which are overcrowded are like they have to bear the burden of the so much overcrowded prison, and the staff is so much less. So we can't blame everything on the prison staff that they are not doing their job properly. We need to at least like put in place the official strength, and the doctors figure is like really alarming. The official strength is 134 doctors for whole of the Uttar Pradesh, and the actual doctors that are posted in all prisons of Uttar Pradesh is 77, and there are around 70 prisons in Uttar Pradesh, including the central prisons. And if we calculate like roughly, it amounts to like 1 doctor per prison, and that is like really very gross, and we should like at least the doctors should be there so that the things medical facilities would fall in place. So the issues basically that I like identified during my work was overcrowding, that already I have pointed out through my the facts which I have shown. Second issue that I found it was basically it is overall the states of India, the inability to furnish the bail amount. That is very much common issue that even when I worked in Maharashtra during my fieldwork days, that during that also I found, and in my work in Uttar Pradesh also. So that is the thing that on which I think already they are like the Supreme Court has passed judgments, and there has been a PIL filed in Delhi High Court also regarding that. But the solutions are not coming to how to improve the conditions of the surety thing. Because in many of the cases, the surety is very much high.
than it should be. Lack of proper monitoring of the ongoing matters. The matters of the under trial prisoner that are being raised in the courts, they are not properly being monitored because of the let's say lawyers, the families are not coming to it. There are a number of reasons for that. Plus, we don't have a centralized database in which all the information is updated. Lack of medical facilities are already pointed out, the shortage of skilled doctors. So, the performance of the district legal service authority is also in question. The performance of legal aid lawyers, as already Professor Raghava has pointed out, the honorary paid to them is very less. But still, they need to, if they take up a case, they need to deliver it. And one major problem in Uttar Pradesh is the state of courts. There are regular strikes, frequent adjournments taken by the advocates, and the dates that are being given during the trial time that are very much like 3 months dates are given. So that prolongs the incarceration period of a trial. Obstacles that I faced during my work basically was gaining access to prison as a difficult task. So you need to be very clear on what issues you need to work in the prison. Then only you can gain proper access. Delay in receiving permission. Anything I had to conduct medical camp inside the prison. I had to take up many official recommendations and permissions, and that takes a lot of time. And by the time you realize that takes a lot of time. So lack of proper channels in place to assist business. So there are mechanisms to assist the business, but there is no proper coordination between them. So there needs to be a bridge between the district legal service authority, the prison staff, and the courts, so as to connect them all, so that the overall benefit is given to the business. Last one is lack of awareness among the stakeholders. The prison staff, the court officials, the legal service authority people, they only are not properly aware about the rights of the prisoners, what things they need to work. So that needs to be improved a little bit. I would like to based on the issues and obstacles faced, I would like to give a few suggestions. The first one, which I have also given, is collaborating with the local institutions, and that can be done in cases of law colleges also. The law students can go to the prison and look after the legal itself, and the medical institutions also can help in setting up medical camps, and that will sensitize both of the segments of the society and help the business also. A system of performance-based review of the honorarium of the legal employees. They should be assessed on the basis of their performance, and that should be the basis of their honorarium. Increase in accessibility of transparency and accountability is improved. Sensitivity towards the rights of prisoners, that needs to be addressed to the whole of the nation. Everyone needs to be sensitized towards the rights of the prisoners. And lastly, the increase in prison staff strength, that is very much required to increase the amount of facilities in the prison and provide them with the basic
In 2016, NASA also came up with an SOP for persons in custody. That also meant that there's a more structured, clear way of how you should have clinics. So, as far as the data was, there were 1,000 legal aid clinics as of 2018. That's NASA's information. But I would agree with the last speaker when he said paper pay, but doesn't really mean that it's functioning. And that's something that we looked at through our studies, where for every legal aid clinic you're supposed to have already paralegals who will be trained. You have to have jail visiting lawyers who are supposed to be regularly visiting these prisons, and you're supposed to also have community paralegals who regularly visit and see what is happening. What we found is that in many prisons, you don't have paralegals at all. So how do you really identify if there's somebody in need of legal aid? That's being challenged. Where paralegals are there, they're not usually trained. They're not aware of what they're expected to do. And there are different forms in which these clinics work. So, for example, in Rajasthan, you have these legal awareness teams rather than actually a judicial lawyer. In Tamil Nadu, you have a parallel process where every panel lawyer is supposed to on a rotational basis visit prisons. In Sikkim, it's where you don't have a concept of judicial lawyers because it's a small setup where your panel lawyers actually who are representing are supposed to visit. So one of the things that we noticed was
what is the amount of time being taken in assigning lawyers? And so the way the process works is, I was, for example, if I was arrested, taken to police custody, then inside prison, I would apply for legal aid. The form would actually go to from the prison to the legal authorities. Then an appointment will happen, and then the letter would come to me. We tried to slice this process up, and realized that there were so many gaps in each of these processes. And so, for example, Rajasthan and Assam, we found it took more than 50 days just between the application being received and the appointment happening. In Assam, it took about 20 days. However, in Kerala and MP, it happened the same day. So there are huge stark differences in how different states are functioning. I remember in Mandya, from Mandya, the information which we got was that the application was actually signed in 2015, actually reached the authority in 2016. It was stuck somewhere in the legal system. So these are the gaps that we need to be vigilant about. The other thing is visit of journalistic lawyers. Now, and before the 2016 the NALSA SOP came, there was no clear mandate. So while some states said they usually visit twice a week, there were few who said once a year. So what do we really expect by visiting them? And also, but even if you have a good mandate, are you actually following it? And is somebody checking that mandate? That's another important thing. And we found that and how do you check that mandate? By frequently asking the registers to be submitted or a report to be submitted. Some of the states had really good QK notes, which specifically mentioned after every visit, you're supposed to give us reports. Whereas most states did not get it at all. It's only you only submit the report and you get the money. Another thing that we looked at was visit of panel lawyers. Whether if I'm assigned as a lawyer, I'm actually visiting or not. And from all the conversations that one has realized that this is true for both legal aid and private lawyers, that there's a culture of not visiting your client in court. Again, Jyoti talked about space being a concern. That's extremely true, where a lot of prisons do not have that space where you can have a privileged or even a non-privileged communication with your lawyer. Distance between prisons was another concern. In terms of if the prisons are really far, how do you expect lawyers to go to court? Now, we found in Sikkim where they issued a letter saying we would pay for your transportation if you just go and visit prisons. So those are practices that we may talk about. Should there be a shuttle where you can have between the court and the prison authorities where the space is small? I have 2 minutes. Okay. And as I was talking about registers, what kind of registers are being maintained to know what activity is happening inside prison? An interesting finding was Khagadia jail in Bihar, where they maintain 9 registers. They are classified inmates into multiple categories, so that's a really good practice. The last slide is where I would, and this is something that I will talk later in another session, but the fact about when we're talking about overcrowding and high proportion of trials, it does not start from the prison, it starts much earlier at arrest. And therefore, what safeguards are there at arrest to ensure that there are no unnecessary arrests? And should there be access to legal representation there? Because currently there isn't. And how do we ensure that happens? Thank you.
So what are some of the standard issues that we have seen when it comes to lack of legal aid facilities, infrastructure problems, health facilities, mental health, shortage of staff, correctional personnel? These are problems that you see across the country, and all of us sitting here would know that reforming the prison system in India is no rocket science. There is enough literature, there are enough reports, and it's just showing the lack of political will, because of which this situation continues to be the way it is. A couple of points that I want to highlight, which has emerged from these discussions. One is, the issue of what we found is Aadhaar card that was pointed out in Haryana. That is really a matter of concern, because if you're going to insist for Aadhaar cards to be compulsory for all facilities to be accessed by prisoners, then it's a serious issue that probably needs to be taken up by some of us who are working in the field through PILs, etc. Another interesting point that was brought out by Anshu's presentation was about the complete lack of preparedness when it comes to any kind of disaster situation in prisons across the country. I thought that was a new point that came out from our panel discussion today. the abysmal situation of producing under trials on their court dates and not even being taken to, even after being produced in court, not being taken to the court if they are on remand. That was a point that was brought up through Tapan's presentation. Jyoti's presentation, one issue that got highlighted was the issue of illegal detention, where people who are kept under the custody of an executive magistrate for almost 6 to 8 months before they are produced before the concerned court magistrate. So these are some of the special issues that were highlighted. I was also very glad to find out that there were some good practices which were also highlighted in some of the presentations. The canteen facilities in Haryana seems to be good, and so is the infrastructure. In fact, it's one of the few states where the overcrowding is almost not there. And in Bihar, there was a talk about Khagaria where the records are being maintained very well. One good practice that I would like to highlight from Maharashtra, which I didn't get time to talk about, is a very novel initiative that has been taken by the government of Maharashtra, the Business Department, where they have appointed social workers in 6 prisons of the state. And 20 full-time social workers have been appointed. They're doing very good work. The project is a pilot project right now, and it is being supported by the Tata Trust. An MOU has been signed between the Tata Trust and the government of Maharashtra, and Prayas is a knowledge partner in that initiative. So I now open up the house for questions. We have about 10 to 15 minutes for some questions.
I am from Jindal, working in the metro team. So, especially my question is to Tapan. That since we have seen that you have produced the data of Aligarh district jail, it's quite alarming as compared to the others you have produced. I want to know that in your observation, do you see a minority angle to this? That since one prisoner, if he or she happens to be a minority from a minority community or happens to be a Dalit, does it affect his or her situation inside the prison in terms of having the treatment from the jail officials, or especially in the terms of allocation of work in jail?
Basically, I would like to highlight the issue first about the Aligarh prison, that it combines 2 districts basically, Aligarh and Hathras, because Hathras is also a district but it doesn't have a district jail of its own. So the overcrowding thing is basically much more because of that. And secondly, when you asked about the differential treatment given to the minorities and other things, actually, I didn't notice that kind of treatment given being treated by the officials during the time I visited the prison. It might have been possible that it is being done in my absence or whenever there is no surveillance on the prison officials on that.
I wanted to ask about the condition of the jail courts. From what we've been reading, a lot of it is it all happens inside the jail. There is this practice of plead guilty, move on, plead guilty, move on. So, what in your experience of working in jails, if you could just tell us?
Yeah. I would completely agree with you that jail courts are a huge problem. It is a practice which is been promoted by the Supreme Court as well as the High Courts over the years for petty offences, but they are actually guna kabul courts. In fact, in prison language, they are known as guna kabul courts because they just line up people who are almost pressurized into pleading guilty because they are in petty offences, and so this is unfair. You have fair trial for serious offenders, and you have unfair trial for petty offenders. So that is really an issue that is.
Many of you drafted legal applications for jail inmates. Did you find how much time is taking to reach the concerned magistrate or the concerned judge? Especially in regard to session judges, because the secretary is supposed to be metropolitan or judicial magistrate. So when it comes to session application, if you draft an application in session court, even in Delhi, sometimes it happens that it doesn't reach the concerned judge. Moreover, the time taken is more than 15 or 20 days. So this is also an aspect which need to be identified.
Anybody like to answer this?
Actually, this is the situation when we send applications to the jail. Sometimes the application don't even reach the courts, And this I personally experienced through my findings in Aligarh. So I had filed some applications through the jail process. And when I went to the court and inspected the files, and the applications which were drafted by me, they were not in the file. So that is one problem which needs to be addressed because they went through the proper authority that they implemented, and then also they were not in the post file. So that needs to be addressed.
One solution we have tried in Maharashtra, in some of when the law college students were brought in to write applications, we brought in a practice whereby the application is attached to the remand warrant of the prisoner. So that when the remand warrant is produced before the magistrate, he will really have a look at the application. But there is a problem.
My question is to Sabha. So in your presentation, PPT, you mentioned something, a particular point about technical training through public-private partnership. So can you please elaborate it, especially what are the trainings that were conducted, with the help of who, or in collaboration with who, and to who, for whom? Yeah.
So it is basically for the prisoners. Technical training in terms of what we saw was in technical courses like motor vehicles courses, and technical courses in terms of what they can use outside, and the bodies that were involved were, one was the prison authority, state government, and one was private authorities, either NGOs like India Vision Foundation or Punjab National Bank is also running.
So when you say prisoners, do women also come into this?
IVF is running programs in some women's sections. But as I mentioned, since there's no specific women's jail, so a lot of provisions that they are entitled to are kind of not provided to them. Yeah. So they are the neglected lot basically.
Yeah, my name is Lalita and I'm from Tamil Nadu. With my experience working with the prison department there, I'm not very sure whether it is equal with all the other prisons. But the basic information which should be available to the prisoners without even asking for, is it available in other prisons? Or I don't know whether we need to work on the IEC materials which goes, is it there with your experience? What do you say?
Not to my experience. It's again a serious problem. Even the card that they're supposed to maintain, where the basic details sometimes they are missing. Anybody else would like to?
One thing is what the history ticket, which usually is not there. In some states for that is there. The other thing that is there is a kiosk or e-history tickets. Something like that is something that we started also in Rajasthan, where there are kiosks available also in Haryana, and there is a staff attached. And prisoners turn back and go there and can basically look at all the details with respect to the case and medical whatever medical examinations have happened, what's the next date of hearing. All that information is maintained which can be looked at the case. That's all.
Or some kind of Victorian representation of that, or it is only the person has to inform the prisoner in person.
The boards are not there.
No, one practice there in Haryana case. I have actually painted it on the walls. Like prisoner's rights and even in Chhattisgarh in a couple of places.
एक्चुअली उड़ीसा में अभी राघवन सर और मेरे सीनियर फेलो थे त्रिजित नंदा, वो ये इनिशिएटिव करके एक कॉन्फ्रेंस किए थे जहाँ सारे बहुत सारे डीएलएसए सेक्रेटरी और एनएलए उड़ीसा को इन्वॉल्व किए थे. उसमें वो सर प्रपोजल दिए थे. तो अभी उड़ीसा के जो सारे प्रिजन्स है और पुलिस स्टेशन है सारे ये एक साल पहले ही लगा दिए.
My name is Kubiya Gawal and my question is related to the floor. So one of the problems we established is the overcrowding because of under-trial prisoners, which is because they cannot afford the high bail amounts in the courts. So there's a practice in the USA where you get bail on the basis of oral undertakings. So as lawyers, open to the floor, what do you think in such practice, if implemented in India, would solve the problem of one, overcrowding, second, under-trial prisoners, and third, prison reforms? Thank you.
We already have personal bond. The provision is the same. It's just that it's not being used. So,
but oral undertaking actually has a different ones when you just on the basis of a short plea to the court.
I mean, when personal bond itself is not being implemented, personal bond is nothing but just a person signs saying I'll be present in court. So as an idea, yes, but ultimately judiciary is very reluctant to use these provisions.
And can you enlighten me as to why is there a reluctance on?
So you were asking about this overall. I'll share an instance. So also knows we discussed this in Bihar recently. Patna High Court has a rule that if you have to move away, and near the relatives should come to the court and sign an affidavit, then only court will hear your case. So we were trying to move away of two sex workers, and after trying for 3 months, we couldn't move it. Professor went and met the Chief Justice. He said he will change the rules, but till that time they have to remain inside. It's a judicial ruling. So forget oral story. You can't even move bails. And this is not a prison problem, this is a judicial problem. So
we actually run out of time. I'm extremely sorry. We'll have to close the session here because the organizers are breathing down my neck. So I have to stop it here. It's been a great pleasure being part of this panel, particularly for me because 3 of the panelists here are people who I have taught at some point of time, and so it's a personal satisfaction. Thank you.